Welcome. This video is about California paid leave for pregnant workers and workplace rights. This is brought to you by the California Work and Family Coalition. The coalition is a statewide alliance of organizations united in the belief that all people should have the time and resources to care for themselves and each other. My name is Charlotte Flanders. I'm part of coalition staff, and I'm here today with my colleague, Katie Duberg, to present to you on Know Your Rights. In California, there are laws that support pregnant workers when they need to seek prenatal care, recover from giving birth, bond with their child, and breastfeeding in the workplace. It is important to learn about wage replacement programs and job protection laws. If a pregnant worker is eligible, they can take job-protected paid leave. Finally, when a pregnant worker returns to work after their leave, there are accommodations to support them as breastfeeding parents. Let's begin with state disability insurance for pregnancy and paid family leave for bonding. While on leave in California, how do I get paid? Paid family leave and disability insurance are two halves of a whole. They are both wage replacement programs funded by the California State Disability Insurance Fund, which is funded through employee contributions, your money. In California, we have pay when you can't work if you are pregnant, disabled, caring for a family member, or bonding with a new child. As you see in the graphic, the California State Disability Insurance Fund is comprised of these two programs, disability insurance and paid family leave. What differentiates these two is the reason why you would take leave. As you see here in the top in yellow, disability insurance, you would take this for your own serious health condition or pregnancy-related condition. In the red, you would take paid family leave to bond with a new child, care for a seriously ill family member, or prepare for military exigency. We do have other short videos on your own serious health condition, paid family leave for parents, and paid family leave for caregiving, but today we are focused on paid leave for pregnant workers, for disability insurance, and for paid family leave. So eligibility requirements for paid family leave and state disability insurance. These two programs have similar eligibility requirements for the first two reasons. First is paying to into state disability insurance fund. Two is you have earned at least 300 from which SDI deductions were withheld during a base period. And we have hyperlinked here the EDD calculator, which is the Employment Development Department calculator. The EDD is where these programs are located, and the calculator can help you estimate your contributions. Now, what is different for the eligibility requirements is why you would take these leaves. So for paid family leave is to have a new child or care for a seriously ill family member. For state disability insurance is one, you must be unable to do regular or customary work due to your own serious illness or disability that includes pregnancy, and you must be in the labor market and must have suffered wage loss. How do I know if I'm contributing to SDI, state disability insurance? The simplest way to know is to look at your pay stub. This is an example here of a pay stub. You would look, and if you see in the red box, you would look for something that says CA State Disability Insurance, or sometimes it's referred to as CA SDI. Qualifying reasons for state disability insurance. SDI provides partial pay for the qualifying reasons for your own disability or illness, defined as an illness or injury, either physical or mental, which prevents you from performing your regular or customary work. Disability also includes pregnancy and childbirth. And for more information, what else is considered as a disability for the State Disability Insurance Fund, we have hyperlinked here, and all the slides will be available to you to be able to click on the hyperlinked resources to be able to read more information. Qualifying reasons for paid family leave, PFL. PFL provides partial pay for the qualifying reasons. For parents, it's to bond and care for a newborn, adopted, or foster child. You must take leave within the first year after birth or placement. You can also take PFL for caregiving.
While on state disability insurance and paid family leave, you can receive partial wage replacement, 70% or 90% of normal weekly wages, which is up to $1,681 per week in 2025. 70% or 90% is determined by your income, and the Employment Development Department will determine that during the application process. You can receive state disability insurance for up to 52 weeks, whereas you can receive paid family leave for up to 8 weeks. Your leave can be taken all at once or in parts, hourly, daily, or weekly. And you can apply through the EDD website within 41 days or later with good cause.
It's important to note that citizenship and immigration status do not affect eligibility of paid family leave and state disability insurance benefits. One frequently asked question that we receive is, does an employee have to work a minimum number of hours or days before becoming eligible for paid family leave or state disability insurance benefits? So no, you do not have to work a minimum number of hours or days to be eligible for PFL or SDI benefits. The amount of benefits you receive is determined by the earnings in the base period, not by the number of hours you have worked. Again, we have hyperlinked the calculator here to help you calculate your benefit amount. Disability insurance application for a pregnant parent. So you would create a one-time benefits online account on the EDD website. If you see in the sticky note here, it's edd.ca.gov. You can apply online or by mail. The application will require documents from the physician or medical provider to verify your claim. Please make sure to write down your receipt number found on the confirmation page after completing the application. Once you have finished your disability leave, then you would have to apply for paid family leave for a bonding application for a pregnant parent. For new parents transitioning from disability leave to paid family leave will automatically receive a bonding claim in their account once the final disability insurance payment is issued. The application will ask when you are planning to take bonding leave. And again, it's important to write down the form receipt number found on the confirmation page after completing the application. It's important to keep this number to keep track of all your applications throughout this process. But it's important to note that disability insurance and paid family leave are wage replacement programs only. They do not require your employer to give you your job back when you return from leave. With that, I'm going to hand it over to my colleague Katie to help us understand what is job protection.
Thanks, Charlotte. So let's talk about how to protect your job while on pregnancy, disability, and bonding leave. There are state and federal laws that do protect your job while you are on leave. Your employer is only required to protect your job if you are covered by the state and/or federal laws. If you qualify for job protection, your employer must guarantee your same job or a comparable job when you return from leave and maintain your benefits during leave. Refusing your request for leave or retaliating against you for using or attempting to use leave is also prohibited. So in California, it's important to know about 3 job protection laws. 2 apply to California only: the California Family Rights Act, also known as CFRA, Pregnancy Disability Leave, also known as PDL, and the Family Medical Leave Act, also known as FMLA, which applies to the United States. Today, we will focus on CFRA and pregnancy disability leave because they are stronger laws than FMLA. They cover and protect more California workers. So how do I protect my job while on state disability insurance? Pregnancy disability leave, which can provide up to 4 months of unpaid job protected leave while you are disabled by pregnancy, childbirth, or a related condition. So to be eligible for pregnancy disability leave, you must have a qualifying reason, and it applies to all employers with 5 or more employees, regardless of the length of employment. Employees who qualify for pregnancy disability leave can use this leave for prenatal care. They can use it intermittently, and their employers must continue their health benefits while they're on leave. For an uncomplicated pregnancy, pregnancy disability leave is typically 4 weeks prior to the estimated due date and 6 or 8 weeks after birth. However, if a pregnant person experiences pregnancy complications either prenatally or postpartum, a medical provider can provide a note to extend pregnancy disability leave to up to 4 months. Next, let's talk about how to protect your job while on paid family leave for bonding under the California Family Rights Act. So in order to qualify for job protection under the California Family Rights Act, you need to be taking leave for one of the following qualifying reasons. And for bonding, you would be taking time off to bond with a newborn, recently adopted, or foster child. In addition to having a qualifying reason, to qualify for job protection, you must meet all 3 of these eligibility requirements: have worked at your current job for at least 1 year, have worked 1,250 hours or more in the prior year, which is about 25 hours per week, and work for an employer with 5 or more employees. And this asterisk is here because this is the biggest difference between the California Family Rights Act and FMLA, is that the California Family Rights Act applies to all employers with 5 or more employees. So if you qualify for job protection under the California Family Rights Act or FMLA, you can receive up to 12 weeks per year of job protected but unpaid leave, either all at once or intermittently. When you return to your job after taking leave, you must be restored to your same job or an equivalent job. Your employer must continue your health benefits while you are on leave, and you're protected from discrimination and retaliation. So you do not need to complete an application to be protected by pregnancy disability leave and the California Family Rights Act, but you do need to notify your employer. It's best to notify your employer in writing, and you can find sample letters on our resources slide at the end of this video. So how do wage replacement and job protection laws work together for an eligible worker? So this is how it would work for a pregnant worker who is eligible for state disability insurance, pregnancy disability leave, paid family leave, and the California Family Rights Act, and who has an uncomplicated pregnancy. And you can see wage replacement in the green bar at the top, and job protection and the yellow and orange bar on the bottom. So you can see for 4 weeks of pregnancy, this person could receive partial pay through state disability insurance, and their job would be protected by pregnancy disability leave. Then for 6 or 8 weeks while they're recovering from giving birth, they would receive pay again through state disability insurance, and their job would be protected by pregnancy disability leave. After recovering from birth, they could transition to bonding leave, where they would receive partial pay through paid family leave for up to 8 weeks, and their job would be protected under the California Family Rights Act for up to 12 weeks. If you don't qualify for job protection, you can still use state disability insurance and paid family leave as long as you are paying into the state disability insurance fund. You can ask your employer to hold your job while you're on leave, but unfortunately, your employer would not be legally obligated to do so. So when pregnant workers are ready to return to work after taking leave, they also have rights as breastfeeding and chest feeding parents. And these rights are called lactation accommodations. So all employers in California must have a written lactation accommodation policy. Lactation accommodations also include break time. So employers must provide a reasonable amount of break time. And if possible, break time would run at the same time with any break time already provided. Lactation accommodations also include space. So all California employees have the right to a private space that is not a bathroom, close to their workspace, that is safe, clean, and free from hazardous materials, that contains a place to sit and a surface to place a breast pump, that has access to electricity. And all breast and chest feeding employees must be provided with access to a refrigerator and a sink. A couple of things to note about enforcing lactation accommodations. Employers with fewer than 50 employees may not provide the space requirement, but only if they can show that it is an undue hardship. If an employer has more than 50 employees, they must provide space. If your employer fails to comply with any of these accommodations, we recommend contacting our legal partners, and it's important to document everything when you request accommodations and any communication with your employer about these accommodations. We also wanted to let you know about a new lactation accommodation resource developed by Breastfeed LA and ACLU Southern California, which has more information about these and other lactation accommodations. And as of January 1st, 2023, Californians have new rights. The first relates to chosen family. So California caregivers who qualify for the California Family Rights Act will be able to take caregiving leave for a seriously ill designated person, in addition to the listed family members who they will designate when they request leave from their employers. The designated person can be any individual related by blood or whose association with the employee is the equivalent of a family relationship. And to learn more about these rights, you can watch our video, California Paid Leave for Caregivers. There are also new rights related to bereavement leave. So as of January 1st, 2023, all employees working for an employer with 5 or more employees and who have been employed for at least 30 days will be eligible for up to 5 days of unpaid but job-protected bereavement leave. To learn more about these rights and also how to advocate with us, you can visit paidfamilyleave.org, where we currently have information available in English and Spanish. We also have a brand new resource hub that we developed together with California Work and Family Coalition members, where you can see many other helpful resources about paid leave and related rights. And here are even more helpful resources to understand paid leave, resources for parents, caregivers, and your own serious health condition, and links to helpful sites on the Employment Development Department website. Thank you so much for watching this video with us. And if you have more questions, you can reach out to us at info@workfamilyca.org.